The following end-user license agreement for the AT&T Uverse app can be found on the AT&T website at att.com/legal/terms.uverseapp.eula.html. There will be a link below in the video's description. End-user license agreement for AT&T Uverse app, effective November 7, 2023. Please read this end-user software license agreement license carefully before clicking the Accept button or downloading or using the AT&T Uverse app application. These terms are an agreement between you and Southwestern Bell Telephone Company, Pacific Bell Telephone Company, Illinois Bell Telephone Company, Indiana Bell Telephone Company, Incorporated, Michigan Bell Telephone Company, Nevada Bell Telephone Company, the Ohio Bell Telephone Company, Wisconsin Bell Incorporated, or Bell South Telecommunications Incorporated, each individually and collectively referred to as AT&T, or we, and its affiliates. Individually and collectively, AT&T, or we, you, your, and licensee in this license refer to you, an individual, and or to the company or other legal entity on whose behalf you accept this license. This license is subject to the arbitration provision included in Section 11 of this license, which requires USTO resolve disputes through arbitration on an individual basis rather than jury trials or class actions. This is the same arbitration clause contained in the Uverse TV Terms of Service effective May 5, 2021, as amended from time to time. This application is not intended for use by persons under the age of 13. If you are under 13 years old, you may not use this application or provide AT&T with any personally identifiable information. If you are 13 or older but not of legal age to enter into a contract, you should review these terms and conditions with your parent or guardian to make sure that you and your parent or guardian understand these terms and conditions. By clicking the Accept button or downloading, installing, or using the application, you affirm that you are either over the age of majority in your jurisdiction of residence, or are an emancipated minor, or possess legal parental or guardian consent, and that you are fully able and competent to enter into the terms, conditions, obligations, affirmations, representations, and warranties set forth in this license and in the related agreements, and to abide by and comply with this license and the related agreements. As used herein, application includes, without limitation, any services specific to the application, excluding, however, your applicable wireless service plan, software code, scripts, interfaces, graphics, displays, text, images, artwork, music or video clips, documentation and other components or content, and any updates, modifications, or enhancements to these items accompanying the application or this license. This application is licensed, not sold, to you by AT&T for use strictly in accordance with the terms and conditions of this license. By clicking the Accept button or downloading or using the application, you are entering into and agreeing to be bound by the terms of this license, the AT&T Acceptable Use Policy located at att.com/AUP, and the DirecTV Privacy Policy located at directv.com/privacy/video-privacy-policy. Each as amended from time to time, which policies are incorporated herein by reference. If at any time after reviewing the application you wish to terminate this license, you must uninstall and remove the application from your device and delete any copy in your possession. Your purchase and use of the application also may be governed by terms and conditions required by 1. Any applicable third-party content and service providers, 2. The manufacturer and other providers of your device and its hardware and software components, including its operating system. 3. The online store or other applicable distributor through which you obtain the application. 4. The applicable wireless service agreement for your device. 5. Any applicable open source or third-party software license. And 6. The terms or conditions governing your personal accounts for web content services you access through the application. 1 through 6. Including without limitation those terms listed in the third-party terms section of this license, collectively being referred to as the related agreements. No related agreement, however, shall have the effect of limiting, encumbering, or otherwise restricting AT&T's rights and remedies or your obligations under this license, or waiving any restrictions on your rights to use the application under this license. This license shall not have the effect of limiting, encumbering or otherwise restricting AT&T's rights and remedies or your obligations under any related agreement between you and AT&T, or waiving any restrictions on your rights under any related agreement between you and AT&T. You understand and agree that even if you are not the account holder for your device, your purchase and use of the application is governed by terms and conditions in the applicable service wireless service agreement for your device. Some versions of this application contain Nielsen's measurement software license to AT&T by the Nielsen Company, U.S., LLC, Nielsen. Nielsen's software collects anonymous usage, device, and viewing data for market research. When you use this application to watch TV shows and other programs, some of your viewing will contribute to Nielsen's TV ratings. To opt out of Nielsen data collection, you can do so within the application by selecting Nielsen information from within the application settings, or on some devices, by selecting Preferences, then Nielsen information. Within the Settings menu, you can opt back in by following the same path. Your opt-out is specific to your device, so if you have more than one device that contains the application, you must opt out within the application on each device. You can continue to use the application even if you opt out of the Nielsen software data collection. The use of the information collected by the Nielsen software is governed by Nielsen's privacy policy located at nielsen.com/digitalprivacy. Please visit this link to learn more about the measurement software and your choices regarding Nielsen's measurements. The Uverse app uses services provided by two different third-party analytics companies, Flurry and New Relic, to obtain information about how you use the app and how the app functions on your device. We use the information provided by these services to improve the Uverse app, as well as customer experience while using the app. For example, learning which Uverse app features are utilized more than others through information provided by Flurry and New Relic, and about what caused a crash of the app through information provided by New Relic, can help AT&T develop better features for future versions of this app. Flurry and New Relic are enabled by software embedded in the Uverse app that transmits information to their respective servers for analysis and reporting. For Flurry and New Relic analytics, that information includes items such as session start and stop time, channels selected, hash device identifiers, and the number of times particular content within the Uverse app is selected. For New Relic crash logging, it includes items such as a hash device identifier, time and date of the crash, ID New Relic has assigned to the Uverse app, the software platform on which the Uverse app is running, and other information regarding the state of the Uverse app at the time of a crash. AT&T authorizes Flurry and New Relic to collect information only as needed for the purposes specified in this section. AT&T uses only Flurry Analytics and Flurry Analytics Reports services. If you do not want Flurry Analytics to collect information related to the use of the Uverse app from your device, you may opt out of Flurry data collection by going to dev.flurry.com/secure/optout.do and following the instructions at the site. If you opt out, Flurry will cease collection of information related to your use of the Uverse app, as well as any other application on your device that contains the Flurry software agent. For more information about Flurry and its privacy policy, please go to policies.yahoo.com/us/en/yahoo/privacy/index.htm. If you do not want New Relic to collect information related to the use of the Uverse app from your device, you may opt out of New Relic data collection by going to Preferences in the Uverse app, selecting Diagnostics, and turning the toggle switch for Enable Diagnostics to off. If you opt out, the Uverse app will no longer send information to New Relic. For more information about New Relic and its privacy policy, please go to newrelic.com/privacy. In addition, we may use AppTentive to send you a survey so that you can respond and share your feedback on the app in real time. These surveys will allow us to collect information that will be aggregated and anonymized for the purpose of improving the product. For information, go to apptentive.com/terms. If AT&T makes any updates or upgrades to the application available to you, such updates or upgrades shall be subject to the terms and conditions of this license unless the application is expressly provided to you under other or additional terms and conditions, in which case, those other or additional terms and conditions, which may include the payment of additional fees, shall apply. Section 1. The application. The application allows Uverse TV subscribers with a compatible device and a qualifying TV package to browse your Uverse TV guide, manage your Uverse TV DVR, If you have a DVR, stream select video content based on your U-verse TV package over a Wi-Fi connection and/or cellular data network. Streaming over the cellular data network may not be available for all content. Receive show recommendations based on favorites you select and manage parental controls through master account. Section 1.1. Video resolution. Resolution of video content can be affected by the format of the content we receive, the variety of internet connections and device screens used, and other reasons. So, while we can't guarantee a specific resolution, we use video optimization technology to provide a better experience, and content is commonly viewable in 480p. Section 1.2. High-speed internet. Additionally, with a subscription to AT&T Internet service, you can pair the application with a U-verse TV receiver over your in-home Wi-Fi network too. Use your device as a remote to control your U-verse TV, for example, change channels, set recordings, etc. And view on your device select information, for example, photos, cast biographies, etc., about TV shows while you also watch them on your TV. Additional functionality may be added to the application in the future as part of new application releases. A detailed description of the features in the most recent application release can be found at uverse.com/uverse/uverse-app. Use of this application will count towards your internet data usage allowance. Application channel availability, programming, and features are subject to change at any time without notice. Programming content is subject to blackout. Data charges may apply. Section 2. Consent to use location information. This application accesses and uses your location information in order to customize the content you access through this application. By using this application, you agree that AT&T may collect information about your location and use such information to provide you allowable video content for your location. AT&T does not retain location information longer than is necessary for such use. AT&T may also aggregate your location data after removing or obscuring any of your personally identifiable information for purposes such as reporting usage as well as maintenance and improvement of the application. This notice will serve as your sole notice that the application may collect your location information, and you may not receive any reminders or further notice. Section 3. License grant and use restrictions. Section 3.1. License grant. Subject to the restrictions set forth in Section 2, AT&T grants you a personal, revocable, non-exclusive, non-transferable, limited right to install and use one copy of the application on a single device owned and controlled by you, device, and to access and use the application on such device solely for your personal entertainment use, strictly in accordance with the terms and conditions of this license, the related agreements, and all applicable local, national, and international laws and regulations. You represent, warrant, and agree that you are using the application solely for your own personal entertainment use and not for redistribution or transfer of any kind. This application may be used in the United States of America only. Section 3.2. Restrictions on use. You shall not a. Decompile, reverse engineer, disassemble, attempt to derive the source code of, or decrypt the application, even for research purposes. b. Make any modification, adaptation, improvement, enhancement, translation, or derivative work from the application. c. Violate any applicable laws, rules, or regulations in connection with your access or use of the application. d. Remove, alter, or obscure any proprietary notice, including any notice of copyright or trademark of AT&T or its collaborators, suppliers, or licensors. e. Use the application in a manner that derives revenue directly from such use, or use the application for any other purpose for which it is not designed or intended. f. Install. Use or permit the application to exist on more than one device at a time or on any other mobile device or computer. g. Distribute the application to multiple devices. h. Make the application available over a network or other environment permitting access or use by multiple devices or users at the same time. I. Use the application for creating a product, service, or software that is, directly or indirectly, competitive with or in any way a substitute for any services, product, or software offered by AT&T. J. Use the application to send automated queries to any website or to send any unsolicited commercial email. K. use any proprietary information or interfaces of AT&T or other intellectual property of AT&T in the design, development, manufacture, licensing, or distribution of any applications, accessories, or devices for use with the application. L. Circumvent, disable, or tamper with any security-related components or other protective measures applicable to the application or the device. Or M. Reproduce, archive, retransmit, distribute, disseminate, sell, lease, rent, exchange, modify, broadcast, synchronize, publicly perform, publish, publicly display, make available to third parties, transfer, or circulate the application. You agree to abide by the rules and policies established from time to time by AT&T. Such rules and policies may include, for example, required or automated updates, modifications, and/or reinstallations of the application and obtaining available patches to address security, interoperability, or performance issues. These obligations survive termination of this license. Section 4. Intellectual Property Rights. Section 4.1. Rights to application. You acknowledge and agree that the application, any copies thereof, including without limitation any copy that you download, install, or use on your device, and all copyrights, patents, trademarks, trade secrets, and other intellectual property rights associated therewith are, and shall remain, the property of AT&T or its collaborators, licensors, or suppliers. Furthermore, you acknowledge and agree that the source and object code of the application and the format, directories, queries, algorithms, structure, and organization of the application are the intellectual property and proprietary and confidential information of AT&T and its collaborators, licensors, and suppliers. Title to the application shall remain with AT&T. AT&T and its collaborators, licensors, and suppliers reserve the right to change, suspend, terminate, remove, impose limits on the use of or access to, disable access to, or require the return of the application or any copy thereof at any time without notice and will have no liability for doing so. Except as expressly stated in this license, you are not granted any intellectual property rights in or to the application by implication, estoppel, or other legal theory. And all rights in and to the application not expressly granted in this license are hereby reserved and retained by AT&T. These obligations survive termination of this license. Section 4.2. AT&T Marks. You acknowledge and agree that the following company names and their related logos and all related product and service names, design marks, and slogans are trademarks and service marks owned by and used under license from AT&T, AT&T. AT&T Uverse, AT&T Uverse Enabled, AT&T Uverse App, AT&T Uverse Mobile, and AT&T Uverse on Tablet. The AT&T marks. You are not authorized to use the AT&T marks in any advertising, publicity, or in any other commercial manner without the prior written consent of AT&T, which may be withheld for any or no reason. These obligations survive termination of this license. Section 4.3. Open source software. The application may utilize or include third-party software that is subject to open source license terms. Open source software. You acknowledge and agree that your right to use such open source software as part of the application is subject to and governed by the terms and conditions of any applicable open source license, including, without limitation, any applicable acknowledgments, license terms, and disclaimers contained therein collectively, the open source license terms. In the event of a conflict between the terms of this license and the open source license terms, the open source license terms shall control. Section 5. No responsibility for third-party content and services. Section 5.1. General. You acknowledge that the application may permit access to products, services, websites, advertisements, promotions, recommendations, advice, information, and materials created and provided by advertisers, publishers, content collaborators, marketing agents, vendors, and other third parties, third-party content and services. Section 5.2. Disclaimer. You acknowledge that AT&T does not investigate, monitor, represent, or endorse the third-party content and services, including any third-party websites accessed through the application. Furthermore, your access to and use of the third-party content and services is at your sole discretion and risk. and AT&T shall have no liability to you arising out of or in connection with your access to and use of the third-party content and services. Third parties may collect information about you and your device if you choose to use third-party content and services. AT&T and its collaborators, suppliers, and licensors are not responsible for third parties' data collection practices. AT&T encourages you to review the third party's privacy policies. Section 5.3. Third-party terms of service. You acknowledge and agree that your access to and use of the third-party content and services and any correspondence or business dealings between you and any third party using the application are governed by and require your acceptance of the terms of service of such third party, including, without limitation, any terms, privacy policies, conditions, representations, warranties, or disclaimers contained therein. You assume all risks arising out of or resulting from your transaction of business over the Internet and with any third party, and you agree that AT&T and its collaborators, suppliers, and licensors are not responsible or liable for any loss or result of the presence of information about or links to such advertisers or service providers. Furthermore, you acknowledge and agree that this license does not grant you any license to 1. The third-party content and services, 2. Any products, services, processes, or technology described in or offered by the third-party content and services. Or 3. Any copyright, trademark, patent, or other intellectual property right in the third-party content or services or any products, services, processes, or technology described or offered therein. You agree that you will not use third-party content or services in a manner that would infringe or violate the rights of any other party, and that AT&T and its collaborators, suppliers, and licensors are not in any way responsible for any such use by you. Section 5.4. Endorsements. You acknowledge and agree that the provision of access to any third-party content and service shall not constitute or imply any endorsement by AT&T of such third-party content and services. AT&T reserves the right to restrict or deny access to any third-party content and services otherwise accessible through the application, although AT&T has no obligation to restrict or deny access even if requested by you. Section 5.5. Inaccurate or inappropriate materials. You understand that by accessing and using the third-party content and services, you may encounter information, materials, and subject matter, 1. That are incomplete or inaccurate, 2. That you or others may deem offensive, indecent, or objectionable, 3. Which may or may not be identified as having explicit language, and 4. That automatically and unintentionally appears in search results as a link or reference to objectionable material. Notwithstanding the foregoing, you agree to use the third-party content and services at your sole risk and that AT&T and its collaborators, suppliers, and licensors shall have no liability to you for information, material, or subject matter that is found to be incomplete, inaccurate, offensive, indecent, or objectionable. Section 6. User-submitted content. Section 6.1. The application may contain features that allow you to submit, post, or display content through the application. You may not use or allow others to use the application, directly or indirectly through your device or wireless number, nor upload, distribute, transmit, communicate, link to, public, or access any data, information, or material through, using, or otherwise in connection with the application that a. is libelous, defamatory, vulgar, or obscene, pornographic, sexually offensive or explicit, harmful or harassing, threatening, hateful, racially, culturally, ethnically, or otherwise objectionable or offensive, discriminatory, or abusive, b. violates any law or regulation or the rights of others, or c. infringes any copyright, trademark, or other intellectual property right, or any proprietary or personal rights or confidentiality obligations of others. You are solely responsible and liable for any such activity, behavior, use, and conduct. This means that you, and not AT&T or its collaborators, suppliers, or licensors, are entirely responsible for all content that you provide via the application. AT&T reserves the right to filter, edit, or control the user-submitted content posted via the application and does not guarantee the accuracy, integrity, or quality of such content. Under no circumstances will AT&T or its collaborators, suppliers, or licensors be liable in any way for any user-submitted content, including, but not limited to, any errors or omissions in any content, or any loss or damage of any kind incurred as a result of the use of any such content posted, emailed, transmitted, or otherwise made available via the application. Section 6.2. If you provide content through the application, user submission, you grant AT&T a royalty-free, perpetual, irrevocable, non-exclusive, and fully sublicensable and transferable right and license to use, reproduce, modify, adapt, publish, translate, create derivative works from, distribute, perform, and display your user submission in whole or part, worldwide, and or to incorporate it in other works in any form, media, or technology now known or later developed, and to exercise the same rights with respect to such works without compensation or attribution to you. You also hereby waive any moral rights in your user submission. AT&T is under no obligation to post or use any user submission you may provide, and AT&T may remove your user submission at any time in its sole discretion. You agree that AT&T is not under any obligation of confidentiality, express or implied, with respect to your user submission. You represent and warrant that you own or otherwise control all necessary rights, consents, and permissions to your user submission necessary to submit such material and to grant AT&T all of the license rights granted herein. Section 7. Term and termination. This license shall be effective until terminated. AT&T may, in its sole and absolute discretion, at any time and for any or no reason, suspend or terminate this license and the rights afforded to you hereunder with or without prior notice. Furthermore, if you fail to comply with any terms and conditions of this license, then this license and any rights afforded to you hereunder shall terminate automatically, without any notice or other action by AT&T. Upon the termination of this license, you shall cease all use of the application and uninstall the application. AT&T may, without notice to you, disable the application. AT&T will not be liable to you or any third party for compensation, indemnity, or damages of any sort as a result of terminating this license in accordance with its terms, and termination of this license will be without prejudice to any other right or remedy AT&T may have, now or in the future. These obligations survive termination of this license. Section 8. Disclaimer of warranties. You acknowledge and agree that the application, including all content contained therein or access thereby, is provided on an as-is and as-available basis, and that your use of or reliance upon the application and any third-party content and services accessed thereby is at your sole risk and discretion. AT&T and ITS collaborators, suppliers, and licensors hereby disclaim any and all representations, warranties, and guarantees regarding the application and third-party content and services, whether oral, express, implied, or statutory, and whether arising by law, statute, usage of trade, custom, course of dealing, or performance of the parties, or the nature or context of this license, and including, without limitation, the implied warranties of merchantability, fitness for a particular purpose, and non-infringement. Furthermore, AT&T and ITS collaborators, suppliers, and licensors make no warranty that 1. The application or third-party content and services will meet your requirements. 2. The application or third-party content and services will be uninterrupted, accurate, reliable, timely, secure, free from viruses or other harmful components, or error-free. 3. The quality of any products, services, information, or other material accessed or obtained by you through the application will be as represented or meet your expectations. Or 4. Any errors in the application or third-party content and services will be corrected. No advice or information, whether oral or written, obtained by you from AT&T or from the application shall create any representation, warranty, or guarantee. Furthermore, you acknowledge that AT&T and ITS collaborators, suppliers, and licensors have no obligation to correct any errors or otherwise support or maintain the application. You acknowledge that the application is not intended or suitable for use in situations or environments where the performance of, use or misuse of, failure of, or errors or inaccuracies in the content, data, or information provided by the application could lead to death, personal injury, or severe physical, property, or environmental damage. AT&T and ITS collaborators, suppliers, and licensors do not warrant that the application will be compatible or interoperable with your device or any other piece of hardware, software, equipment, or device installed on or used in connection with your device. Furthermore, you acknowledge that compatibility and interoperability problems can cause the performance of your device to diminish or fail completely and may result in permanent damage to your device, loss of the data located on your device, and corruption of the software and files located on your device. You acknowledge and agree that AT&T and ITS collaborators, suppliers, and licensors, and their officers, directors, employees, and agents shall have no liability to you for any losses suffered, resulting from or arising in connection with compatibility or interoperability problems. Should the application prove defective, you assume the entire burden of all necessary expenses, servicing, repair, or correction. This Section 8 shall survive termination of this license. Notwithstanding, and without waiving the foregoing, the terms and conditions of the related agreements may provide limited remedies to you. Section 9. Limitation of liability. Except to the extent prohibited by law, under no circumstances shall AT&T, its collaborators, suppliers, or licensors, nor their officers, directors, employees, and agents, be liable for accidents, property damage, personal injury, death, or for any indirect, incidental, consequential, punitive, special, or exemplary damages arising out of or in connection with the sale or distribution of, the performance or non-performance, or your access or use of or inability to access or use the application, and any third-party content and services, whether or not the damages were foreseeable and whether or not such party was advised of the possibility of such damages. Without limiting the generality of the foregoing, AT&T's aggregate liability to you, whether under contract, tort, statute, or otherwise, shall not exceed the greater of 1. The initial purchase price paid by you for the application, 2. The aggregate amount you paid to AT&T for the application during the 1 month preceding the date that the claim arises, or 3. $2. The foregoing limitations will apply even if the above stated remedy fails of its essential purpose. This Section 9 shall survive termination of this license. Section 10. Indemnification. You shall indemnify, defend, and hold harmless AT&T and its collaborators, suppliers and licensors, and their officers, directors, agents, and employees, the indemnified parties, from and against any claim, proceeding, loss, damage, fine, penalty, interest, and expense, including, without limitation, fees for attorneys and other professional advisors, arising out of or in connection with the following. 1. Your access to or use of the application or third-party content and services. 2. Your breach of this license. 3. Your violation of law. 4. Your negligence or willful misconduct. Or 5. Your violation of the rights of a third party. You will promptly notify AT&T in writing of any third-party claim arising out of or in connection with your access to or use of the application. These obligations survive termination of this license. Section 11. Dispute resolution. Please read this carefully. It affects your rights. Section 11.1. Summary. This part of the agreement outlines how disputes between you and AT&T will be resolved through our informal dispute resolution process, individual arbitration, or small claims court. The informal dispute resolution process gives you the opportunity to explain what happened to someone in, or working with, our legal department. Under the terms of this agreement, AT&T is encouraged to resolve issues early, without going any further. An arbitration is a less formal alternative to a lawsuit or jury trial in court. A neutral third party, called an arbitrator, decides the dispute. The arbitrator applies the same law and can award the same individualized remedies that a court could award, but uses streamlined procedures and limits discovery to simplify the process and reduce costs. The arbitrator's decision is legally binding, and it is subject to very limited review by courts. You and AT&T agree that arbitration will take place on an individual basis. Class arbitrations, class actions, and representative actions are not permitted. This means that you and AT&T will neither file a lawsuit in any court other than a small claims court, nor pursue or participate in an action seeking relief on behalf of others. While subsection 11.2 lays out the specifics, here are the steps you would take to resolve a dispute. Contact customer service. We encourage you to give customer service a call first. A phone call, chat session, or email with us is usually the quickest way to resolve an issue. Check out att.com/contact us to find the right service or product team for your issue. You choose. If you aren't satisfied after talking to customer service, you can choose to file your individual claim in small claims court or send us a notice of dispute, which is required before starting arbitration. Let's work it out. If you decide not to go to small claims court, start the informal dispute resolution process by sending a notice of dispute to our legal department, which you can complete and send online. You and AT&T agree to give each other at least 60 days to share information and try to reach an agreement. We'll use the same process if we have a dispute with you. At your or our request, we'll schedule an informal settlement conference to try to reach an agreement by phone or video conference. Pursue an arbitration. If the dispute still isn't resolved, you can pursue an individual arbitration. The nation's largest nonprofit arbitration provider, the American Arbitration Association, AAA, will administer the arbitration and select the neutral arbitrator, with input from both you and AT&T. Some things to keep in mind. AT&T will usually pay all of the arbitration fees, with some exceptions. Any hearings will be in the same county as your billing address, or they might be held by phone or video conference. In some cases, if you win, we will pay double attorney's fees, if any, and a minimum of $10,000. There are special rules for coordinated or mass arbitrations, where the same lawyers or a group of coordinated lawyers seek to file 25 or more similar arbitrations. If you choose to be part of those proceedings, the cases will proceed in stages, so it might take longer to arbitrate your dispute than it would otherwise. Section 11.2. Arbitration Agreement. Section 11.2.1. Claims subject to arbitration. To the greatest extent permitted by law, AT&T and you agree to arbitrate all disputes and claims between you and AT&T, except for claims arising from bodily injury or death. This arbitration provision is intended to be broadly interpreted. It includes, but is not limited to, claims arising out of or relating to any aspect of the relationship between us, whether based in contract, tort, fraud, misrepresentation, or any other statutory or common law legal theory. Claims that arose before the existence of this or any prior agreement including, but not limited to, claims relating to advertising. Claims for mental or emotional distress or injury not arising out of bodily injury. Claims that are currently the subject of purported class action litigation in which you are not a member of a certified class, and claims that may arise after the termination of this agreement. References in Section 11 to AT&T or we include our past, present, and future parents, subsidiaries, affiliates, and related entities, as well as AT&T's and all of those entities' officers, agents, employees, licensors, predecessors in interest, successors, and assigns. References in Section 11 to you include your past, present, and future parents, subsidiaries, affiliates, related entities, agents, employees, predecessors in interest, successors, and assigns, and all authorized or unauthorized users or beneficiaries of AT&T services or products under past, present, or future agreements between you and AT&T. Small claims option. Despite this arbitration provision, either you or AT&T may bring an action seeking only individualized relief in the small claims court for the county or parish of your billing address, so long as the action is not removed or appealed to a court of general jurisdiction. This arbitration provision does not preclude you from bringing issues to the attention of federal, state, or local agencies, including, for example, the Federal Communications Commission. Those agencies can, if the law allows, seek relief against us on your behalf. By entering into this agreement, you and AT&T are each waiving the right to a trial by jury or to participate in a class action. This agreement evidences a transaction in interstate commerce, and thus the Federal Arbitration Act governs the interpretation and enforcement of this arbitration provision. This arbitration provision will survive termination of this agreement. Section 11.2.2. Pre-arbitration and formal dispute resolution process. Customer service is available to help and usually can resolve any concerns you may have. If that does not work, the first step in the dispute resolution process is to send a written notice of dispute notice. We'll also send you a notice to your billing address if we have a dispute with you. You may download the notice form at att.com AT&T.com/arbitration-forms. The notice to AT&T may be sent by U.S. mail or professional courier service to Legal Department. Notice of Dispute. AT&T, 208 South Accord, Office Number 2900.13, Dallas, Texas, 75202. The notice address. Or, alternatively, submitted electronically by following the instructions at att.com/notice of dispute. The notice must include all of the information requested on the notice form, including a. the claimant's name, address, and phone number, b. the account number at issue, c. the services, if any, to which the claim pertains, d. a description of the nature and basis of the claim or dispute, and e. an explanation of the specific relief sought and the basis for the calculations. The notice must be personally signed by you, if you are the claimant, or by an AT&T representative, if we are the claimant. To safeguard your account, you might be required to provide both your authentication and consent for us to discuss your account or share your account information with anyone but you, including an attorney, authentication, and consent. Whoever sends the notice must give the other party 60 days after receipt of a complete notice, including your authentication and consent, if required, to investigate the claim. During that period, either you or AT&T may request an individualized discussion by phone call or video conference regarding settlement, informal settlement conference. You and AT&T must work together in good faith to select a mutually agreeable time for the informal settlement conference, which can be after the 60-day period. You and an AT&T representative must personally participate, unless otherwise agreed in writing. Your and AT&T's lawyers, if any, also can participate. Any applicable statute of limitations or contractual limitations period will be told for the claims and requested relief in the notice during the informal resolution period. The informal resolution period is the number of days between the date that the complete notice and authentication and consent, if required, is received by the other party and the later of 1. 60 days later, or 2. the date the informal settlement conference is completed, if timely requested. Any arbitration proceeding cannot be commenced until after the informal resolution period has ended. Subsection 11.2.7 contains additional requirements for commencing certain coordinated arbitrations. All of the pre-arbitration dispute resolution requirements are essential so that you and AT&T have a meaningful chance to resolve disputes informally. If any aspect of these requirements has not been met, a court can enjoin the filing or prosecution of an arbitration. In addition, unless prohibited by law, the AAA may not accept, administer, assess, or demand fees in connection with such an arbitration. If the arbitration already is pending, it must be dismissed. Any applicable statute of limitations or contractual limitations period will be told for the claims and requested relief in the notice during the informal resolution period. The informal resolution period is the number of days between the date that the complete notice and authentication and consent, if required, is received by the other party and the later of 1. 60 days later, or 2. the date the informal settlement conference is completed, if timely requested. Any arbitration proceeding cannot be commenced until after the informal resolution period has ended. Subsection 11.2.7 contains additional requirements for commencing certain coordinated arbitrations. All of the pre-arbitration dispute resolution requirements are essential so that you and AT&T have a meaningful chance to resolve disputes informally. If any aspect of these requirements has not been met, a court can enjoin the filing or prosecution of an arbitration. In addition, unless prohibited by law, the AAA may not accept, administer, assess, or demand fees in connection with such an arbitration. If the arbitration already is pending, it must be dismissed. Section 11.2.3. Arbitration Procedure. You may download a form to initiate arbitration at att.com/arbitration-forms. In addition, information on how to commence an arbitration proceeding, including how to file a consumer arbitration online, is at adr.org/support. A copy of the arbitration demand must be sent to AAA and the notice address, and a copy of the notice must be attached to your arbitration demand. The arbitration will be governed by the then-current consumer arbitration rules, AAA rules, of the AAA, as modified by this arbitration provision, and will be administered by AAA. If AAA refuses to enforce any part of this arbitration provision, you and AT&T will select another arbitration provider. If there is no agreement, the court will do so. The AAA rules are available online at adr.org or may be requested by writing to the notice address. You may obtain information that is designed for non-lawyers about the arbitration process at att.com/arbitration-information. As in court, you and AT&T agree that any counsel representing someone in arbitration certifies that they're complying with the requirements of Federal Rule of Civil Procedure 11b, including a certification that the claim or the relief sought is neither frivolous nor brought for an improper purpose. The arbitrator is authorized to impose any sanctions available under AAA rules, Federal Rule of Civil Procedure 11, or applicable federal or state law against all appropriate represented parties and counsel. All issues are for the arbitrator to decide, except only a court can decide the following. Issues relating to the scope and enforceability of the arbitration provision. Whether a dispute can or must be brought in arbitration. Whether the AAA cannot or will not administer the arbitration in accordance with this arbitration provision. Whether subsection 11.2.2 has been complied with or violated for purposes of awarding relief under that subsection that a court can award, and whether subsections 11.2.6, 11.2.7, or 11.2.8 have been complied with or violated. The arbitrator may consider rulings in other arbitrations involving different customers, but an arbitrator's ruling will not be binding in proceedings involving different customers. Unless you and AT&T agree otherwise, any arbitration hearings will take place in the county or parish of your billing address. If your claim is valued at $10,000 or less, you may choose whether the arbitration will be conducted solely based on documents submitted to the arbitrator or through a telephonic, video conference, or in-person hearing under AAA rules. If your claim exceeds $10,000, the right to a hearing will be determined by AAA rules. During the arbitration, the amount of any settlement offers must not be disclosed to the arbitrator until after the arbitrator determines the relief, if any, to which you or AT&T is entitled. Regardless of how the arbitration is conducted, the arbitrator must issue a reasoned written decision sufficient to explain the essential findings and conclusions on which his or her decision is based. Except as provided in subsection 11.2.6 below, the arbitrator can award the same damages and relief that a court can award under applicable law. Section 11.2.4. Arbitration fees. We will pay all AAA filing, administration, case management, hearing, and arbitrator fees if we initiate an arbitration. If you initiate arbitration of claims valued at $75,000 or less, we will pay those fees, so long as you have fully complied with the requirements in subsection 11.2.2. In such cases, we will pay the filing fee directly to AAA upon receiving a written request from you at the notice address, or, if AAA requires you to pay the filing fee to commence arbitration, we will send that amount to AAA and request that AAA reimburse you. If, however, the arbitrator finds that either the substance of your claim or the relief sought is frivolous or brought for an improper purpose, as measured by the standards set forth in Federal Rule of Civil Procedure 11b, then the allocation and payment of all such fees will be governed by AAA rules. Section 11.2.5. Alternative payment and attorney premium. If you fully complied with the requirements above in subsection 11.2.2, and the arbitrator issues an award in your favor that is greater than the value of our last written settlement offer made before the arbitrator was selected, then we will pay you the amount of the award or $10,000, the alternative payment, whichever is greater, and pay the attorney you retained, if any, twice the amount of attorney's fees and reimburse any expenses, including expert witness fees and costs, that your attorney reasonably incurs for investigating, preparing, and pursuing your claim in arbitration, the attorney premium. If we did not make a written offer to settle the dispute before the arbitrator was selected, and the arbitrator awards you any relief on the merits, you and your attorney will be entitled to receive the alternative payment and the attorney premium, respectively. Disputes regarding the payment and reimbursement of attorney's fees, expenses, the alternative payment, and the attorney premium may be resolved by the arbitrator upon request from either party made within 14 days of the arbitrator's ruling on the merits. In assessing whether an award that includes attorney's fees and expenses is greater than the value of our last written settlement offer, The calculation will include only the reasonable attorney's fees and expenses you incurred pursuing this arbitration through the date of our settlement offer. The right to the attorney premium supplements any right to attorney's fees and expenses you may have under applicable law. Thus, if you would be entitled to a larger amount under the applicable law, this arbitration provision does not preclude the arbitrator from awarding you that amount. However, you may not recover both the attorney premium and a duplicative award of attorney's fees or expenses. Section 11.2.6. Requirement of individual arbitration. The arbitrator may award relief, including, but not limited to, damages, restitution, declaratory relief, and injunctive relief, only in favor of the individual party seeking relief and only to the extent necessary to provide relief warranted by that party's individual claim. You and AT&T agree that each may bring claims against the other only in your or its individual capacity and not as a plaintiff or class member in any purported class, representative, or private attorney general proceeding. Further, unless both you and AT&T agree otherwise, the arbitrator may not consolidate more than one person's or entity's claims and may not otherwise preside over any form of a representative, class, private attorney general, or public injunction proceeding. If a court, after exhaustion of all appeals, declares unenforceable any of these prohibitions on consolidation or non-individualized relief, such as class, representative, private attorney general, or public injunctive relief, then all other aspects of the case must be arbitrated first. After completing arbitration, the remaining non-arbitrable aspects of the case will then be decided by a court. Section 11.2.7. Administration of coordinated arbitrations. If 25 or more claimants submit notices or seek to file arbitrations raising similar claims and are represented by the same or coordinated counsel, whether such cases are pursued simultaneously or not, all the cases must be resolved in stage proceedings. You agree to this process even though it may delay the arbitration of your claim. In the first stage, claimants' counsel and AT&T will each select 25 cases, 50 cases total, to be filed in arbitration and resolved individually by different arbitrators. If feasible, the arbitrators will be from the respective claimants' home states. If there are fewer than 50 cases, all will be filed in arbitration. In the meantime, no other cases may be filed or proceed in arbitration, and the AAA must not assess or demand payment of fees for the remaining cases or administer or accept them. The arbitrators are encouraged to resolve the cases within 120 days of appointment or as swiftly as possible thereafter, consistent with fairness to the parties. After the first stage is completed, the parties must engage in a single mediation of all remaining cases, and AT&T will pay the mediation fee. If the parties cannot agree how to resolve the remaining cases after mediation, they will repeat the process of selecting and filing 50 cases to be resolved individually by different arbitrators, followed by mediation. If any claims remain after the second stage, the process will be repeated until all claims are resolved, with 4 differences. First, a total of 100 cases may be filed in the third and later stages. Second, the cases will be randomly selected. Third, arbitrators who decided cases in the first 2 stages may be appointed in later stages if different arbitrators are not available. Fourth, mediation is optional at the election of counsel for the claimants. Between stages, counsel will meet and confer regarding ways to improve the efficiency of the stage proceedings, including whether to increase the number of cases filed in each stage. Either party may also negotiate with AAA regarding the amount or timing of AAA fees. If this subsection applies to a notice, the informal resolution period for the claims and relief set forth in that notice will be extended, including the tolling of any applicable statute of limitations or contractual limitations period for the claims and requested relief, until that notice is selected for a stage proceeding, withdrawn, or otherwise resolved. A court will have the authority to enforce this subsection, including by enjoining the mass filing, the prosecution or administration of arbitrations, or the assessment or collection of AAA fees. This subsection and each of its requirements are intended to be severable from the rest of this arbitration provision. If, after exhaustion of all appeals, a court decides that the staging process in this subsection is not enforceable, then the cases may be filed in arbitration and the payment of AAA filing, administration, case management, hearing, And arbitrator fees will be assessed as the arbitrations advance and arbitrators are appointed rather than when the arbitrations are initiated. Section 11.2.8. Future changes to arbitration provision. Notwithstanding any provision in this agreement to the contrary, if AT&T makes any future change to this arbitration provision, other than a change to the notice address, you may reject any such change by sending us written notice via U.S. mail within 30 days of the first notice of the change to Legal Department, Revised Arbitration Opt-out, AT&T, 208 South Ackerd. Office number 2900.13, Dallas, Texas, 75202. Include your name, address, phone number, account number, and a statement personally signed by you that you wish to reject the change to the arbitration provision. By rejecting any future change, you are agreeing that you will arbitrate any dispute between you and AT&T in accordance with the language of this version of the arbitration provision. Section 11.2.9. Puerto Rico customers. For Puerto Rico customers, all references to small claims court in this arbitration provision should be understood to mean the Puerto Rico Telecommunications Regulatory Board. Section 11.3. Forum selection. Unless you and AT&T agree otherwise, to the greatest extent permitted by law, the state and federal courts in Dallas, Texas will have exclusive jurisdiction over any disputes, except for disputes brought in small claims court, that are not subject to arbitration or over any action involving the applicability or enforceability of the arbitration provision or any of its parts. You and AT&T consent to the jurisdiction of those courts and waive any objections as to personal jurisdiction or as to the laying of venue in such courts due to inconvenient forum or any other basis or any right to seek to transfer or change venue of any such action to another court. Section 12. Miscellaneous. The following provisions survive termination of this license. Section 12.1. Governing law, limitation on actions. This license shall be deemed to take place in the state of New York and shall be governed by and construed in accordance with the laws of the state of New York, excluding its conflicts of law principles. This license shall not be governed by the United Nations Convention on Contracts for the International Sale of Goods, the application of which is expressly excluded. To the maximum extent permitted by applicable law, you and AT&T agree that any cause of action arising out of or relating to the application or your use of the application must commence within 1 year after the cause of action accrues. Otherwise, such cause of action is permanently barred. This Section .1 is not intended to and does not alter any provisions of your applicable wireless service agreement. Section 12.2. Contact information. In the event that you have a question, complaint, or claim regarding your use of the application, please call AT&T customer service by dialing 611 from your device if you are an AT&T wireless service subscriber or 1-800-331-0500 or visit att.com/db. Section 12.3. Severability. If any provision of this license is held to be invalid or unenforceable with respect to a party, the remainder of this license, or the application of such provision to persons other than those to whom it is held invalid or unenforceable shall not be affected, and each remaining provision of this license shall be valid and enforceable to the fullest extent permitted by law. Section 12.4. Waiver. Except as provided herein. The failure to exercise a right or require performance of an obligation under this license shall not affect a party's ability to exercise such right or require such performance at any time thereafter, nor shall the waiver of a breach constitute waiver of any subsequent breach. Section 12.5. Jurisdictional issues, export control. This application is intended for use within the United States of America. AT&T makes no representation that this application is appropriate or available for use in other locations. If you choose to access or use the application from other locations, you do so on your own initiative and are responsible for compliance with local laws, if and to the extent local laws are applicable. Access to the application from jurisdictions in which the application, in whole or in part, is illegal or penalized is prohibited. You may not use or otherwise export or re-export the application except as authorized by United States law and the laws of the jurisdictions in which the application was obtained. You represent and warrant that you are not a. Located in any country that is subject to a U.S. government embargo or that has been designated by the U.S. government as a terrorist-supporting country, or b. listed on any U.S. government list of prohibited or restricted parties, including the Treasury Department's list of specially designated nationals or the U.S. Department of Commerce denied persons list or entity list. You also agree that you will not use the application for any purposes prohibited by United States law. Section 12.6. U.S. Government Restricted Rights. The application was developed at private expense and is provided with restricted rights. Use, duplication, or disclosure by the government is subject to restrictions as set forth in subparagraphs A through D of the Commercial Computer Software Restricted Rights Clause at FAR 52.227-19 when applicable, or in subparagraph C.1.2 of the Rights in Technical Data and Computer Software Clause of DFARS, and in similar clauses in the NASA FAR Supplement and their successors, and all other federal laws and regulations that protect licensor rights in privately developed commercial software. Section 12.7. Performance or benchmark testing. You may not disclose the results of any benchmark test using the application to any third party without AT&T's prior written approval. Section 12.8. Modification or amendment. AT&T may modify or amend the terms of this license at any time, with or without notice to you, by posting a copy of the modified or amended license available through the application. You will be deemed to have agreed to any such modification or amendment by your decision to continue using the application following the date in which the modified or amended license is made available through the application. Section 12.9. Survival. Any provisions of this license which by their express language or by their context are intended to survive the termination of this license shall survive such termination. Section 12.10. Third-party beneficiaries. Except as explicitly provided in this license or in the related agreements, nothing contained in this license is intended or shall be construed to confer upon any person, other than the parties hereto, any rights, benefits, or remedies of any kind or character, or to create any obligations or liabilities of a party to any such person. Section 12.11. No transfer by you. You may not rent, lease, lend, sublicense, assign, or transfer the application, this license, or any of the rights granted hereunder. Any attempted transfer in contravention of this provision shall be null and void and of no force or effect. These obligations survive termination of this license. AT&T may assign this license without restriction. Section 12.12. Copyright complaints. AT&T respects the intellectual property rights of others. If you believe that your work has been copied and has been posted, stored, or transmitted by or through the application in a way that constitutes copyright infringement, please submit a notification pursuant to the Digital Millennium Copyright Act, DMCA, by providing AT&T's copyright agent the following written information: an electronic or physical signature of the person authorized to act on behalf of the owner of the copyright interest, a description of the copyrighted work that you claim has been infringed upon, a specific description of where the material that you claim is infringing is located, your address, telephone number, and email address, a statement by you that you have a good faith belief that the disputed use is not authorized by the copyright owner, its agent, or the law, a statement by you, made under penalty of perjury, that the above information in your notice is accurate and that you are the copyright owner or authorized to act on the copyright owner's behalf. AT&T's copyright agent for notice of claims of copyright infringement relating to the application can be reached as follows: Manager of Security and Copyright Infringement, 1800 Perimeter Park Drive, Suite 100, Morrisville, North Carolina, 27560. Phone number 919-319-5737. Fax number 919-319-8154. Email copyright@att.com. For more information about AT&T's copyright protection practices under the DMCA and for information on how to contact AT&T's DMCA agent, please refer to att.com/legal/terms.dmc.html. Section 12.13. Entire agreement. This license, including the documents incorporated herein by reference, constitute the entire agreement with respect to the use of the application licensed hereunder and supersedes all prior or contemporaneous understandings regarding such subject matter. Third-party terms. The below third-party terms are incorporated herein and made part of this license. Apple, FYI Television Incorporated, licensed third-party content. Apple. Additional provisions and usage rules required by Apple Incorporated. Apple may be found at apple.com/legal/iTunes/appstore/us/terms.html. If your device is manufactured by Apple or if you obtain the downloadable application through iTunes, you and AT&T acknowledge and agree that Apple and its subsidiaries are third-party beneficiaries to this license and that, upon your acceptance of the terms and conditions of this license, Apple will have the right to enforce this license against you in its capacity as a third-party beneficiary to the license. Apple shall have no responsibility for any claims made by you or any third party related to the application or your use or possession of the application, including, but not limited to, 1. Product liability claims, 2. Any claim that the application fails to conform to any applicable legal or regulatory requirement, 3. Claims arising under consumer protection or similar legislation, or 4. Any claims, losses, liabilities, damages, costs or expenses attributable to any failure of the application to conform to any warranty, express or implied. If you have paid any fee to Apple for use of the application, in the event of any failure of the application to conform to any applicable warranty, you may notify Apple, and Apple will, as your sole and exclusive remedy, refund to you the purchase price paid, if any, for the application. Apple will have no other warranty obligation whatsoever with respect to the application. Licensed third-party content. Portions of the content accessible through the application are provided by third parties via a license agreement with AT&T, licensed third-party content. By using this application, you are acknowledging that your viewing and use of any such licensed third-party content is subject to the terms of this end-user license agreement, including, but not limited to, the provisions of paragraph 4 related to third-party content and services as applicable in the AT&T acceptable use policy as incorporated herein. With respect to licensed third-party content provided by FYI Television Incorporated, you are acknowledging that your viewing and use of any such licensed third-party content is subject to the terms of use found at fyitelevision.com/support/TOS/hosted content-terms of service. This has been a reading of the end-user license agreement for the AT&T UVerse app, effective November 7, 2023. A link to the full text can be found in the video's description. Feel free to like, comment, and subscribe for more videos. Thanks for watching, and have a nice day.